My name's Forrest Blake. I'm the founder of HIGHRISE Networks and a commercial broker with SVN Commercial. And we are doing a great webinar today with Wendi and her partner, which I lost the name. We'll flip back to that in a second. So Wendi is a brand new member of HIGHRISE. She's starting in our Irvine 5 group, which launches next week. And Wendi is a human resource expert and an executive coach. So as you can see by her bio here, she really works with people, the whole self people, and combines empathy, problem solving, and all those accountability that executives need to get things done. But really her specialty in HR for the last 15 years is building these on-site and off-site and serving as CEO in some cases. So I'm really happy to have such a smart, well-rounded person, a master in clinical psychology. So you know what I'm thinking, right?
Yes. Analyzing you constantly.
Yeah, I can tell. I better put on my poker face, huh? But great to have you, Wendi, and I'm going to hand it over to you. We will be muting everybody. So there's two ways to do this. You can either unmute yourself and ask a question, or there's a chat box which we'll be monitoring so that any questions come across. I know Wendi and Shannon are open to answering those. And in addition, we are recording this session. So if you need to refer back or you forget something or wonder how to reach out to Wendi, we will post that on our website here within a couple of days. So Wendi, with all of that, it's your show. Go ahead.
Okay, thank you so much, Forrest. And I do want to also introduce my colleague, Shannon Wolf, attorney at law and a huge resource for essential HR. So with all this AB5 stuff that's come into play, I've been calling her constantly and asked her to collaborate with me in helping to put together a public service announcement to really our clients because of the liability that's involved here. So with that being said, I've asked her to go over really the legal aspects of it, and then we'll jump in and talk about the critical areas that you need to be concerned about as an employer and our recommendations. So I'm going to have Shannon start off, and thank you so much.
You're welcome. Happy to be here. So we're first going to give you an overview of what we're going to discuss today. And it's important to keep in mind that when we're discussing these laws and AB5, that workers are always presumed to be employees under California law. So the employer always has the burden of proving otherwise. We're going to talk about the Borrello test, and that is the test that was first established in the 80s that was used to determine whether somebody can be classified as an independent contractor. Then we're going to discuss a case, Dynamics, which was issued by the California Supreme Court and radically changed how you determine whether someone can be properly classified as an independent contractor. And the California Supreme Court established the new ABC test. And then we're going to discuss how the legislature responded to this in California. There were a lot of questions, a lot of confusion after Dynamics came down, and what happened resulted in AB5, which became effective this year. So historically, we've had the Borrello test, and that was a California case in 1989. This test is a multi-factor test. It's a balancing test. The most important factor is the level of control and direction that the hiring entity has over the worker. So the more control and direction, whether they have a right to that control or in fact control them, will mean that they'll more likely be considered an employee. And then there are a bunch of other factors that the court will look at to determine whether somebody is an independent contractor or not. And those factors include whether the worker himself or herself holds himself out as being a separate business. Another factor is whether that worker is performing work that's a regular or integral part of the employer's business. Another factor is whether the employer or the worker supplies, the instruments, tools, or the place for the worker doing the work. So, who's incurring that business expense for the computer or the office space? Is it the worker or is it the hiring entity? If it's the hiring entity, they're more likely to be an employee. So continuing on, there are a bunch of other factors, including whether the service provided by the worker requires a special skill, the kind of occupation they're in, whether that's an occupation where it's usually done without supervision by a specialist, and then looking at the method of payment. Are they paid by the time or for the job completed? If they're just an hourly worker, they're more likely to be considered an employee. Another factor the courts will look at is the length of time for which the services are being performed. Is this an indefinite relationship, or is this a relationship where there's an end in sight? So if it's indefinite, they're more likely to be found probably an at-will employee and therefore not an independent contractor. And then the last factor is whether or not the worker and the employer believe they're creating an employer-employee relationship, or do they think they're creating an independent contractor relationship? So is there a written agreement that reflects that they're an independent contractor? So historically, these were all the factors, and as you can see, there are many, and it was not a black and white test, and all these factors were looked at by courts to see whether somebody was properly classified as an independent contractor. Then there was a dramatic shift in April of 2018 when the Dynamex case came down from the California Supreme Court and really radically changed everything and adopted what's called the ABC test. And it's important to remember that all three of the prongs in the ABC test, they have to be met to be properly classified as an independent contractor. So if any one of these prongs we talk about is not met, then they're going to be considered an employee. So going through that list, we have the A prong, whether the worker is free from the control and direction of the hiring entity in connection with the performance of the work. And that's basically the same factor that we talked about under the Borello test that is the most important factor. Are they being controlled and directed by the hiring entity? Okay, so that's the first question. Then for the B prong, the question is whether are they performing work that's outside the usual course of the hiring entity's business. So is that worker, are they doing the same thing that the business does, or are they doing something that's specialized and ancillary to the business? So if you have a business that sells a certain product and you have a worker that's just doing accounting or HR, then they would meet that B prong. But if they're selling the product that the business sells, then they're doing what's part of the integral of the business and they wouldn't meet the B prong. Then the C prong is whether the worker is customarily engaged in an independently established trade, occupation, or business. So do they have their own business? Do they truly have their own business? And the way to establish that is to look at, do they have their own clients or customers? And do they, or at least are they representing them out to the public and advertising and seeking other clients other than yourself or the hiring entity? So this is the ABC test. And after this came down, lots of questions and confusion really ensued on how this applied. And I'll let Wendi now explain the legislative response.
So after the ABC test came into play, we all were scrambling to try to figure out how we could properly classify our workers under there. And the legislature came back and they came forward with a bill, which ultimately got passed and signed by Governor Gavin Newsom on September 18th, 2019, effective as of January 1st, 2020. So basically what AB5 does is it takes the Dynamex ruling and makes the ABC test apply unless an exception is met. And that's where there's a lot of confusion in AB5. So we're going to spend some time talking about the exceptions. And it also integrates for the exceptions that the Borello test, which Shannon just spoke about, has to apply. So this includes that it's under codes for the unemployment insurance and wage orders of the Industrial Welfare Commission. So the reasons that the California legislature says that they passed AB 5 was to basically supply and protect employees with basic law and employment protections, provide them with minimum wage and overtime rights, with the paid sick days that is required under California state law, provide them with workers' compensation benefits and unemployment benefits that as an independent contractor they would not be eligible for. They also wanted to force employers to pay Social Security, Medicare, unemployment insurance, workers' compensation insurance, and state income taxes. So really here, what I keep telling my clients is that California wanted their money and the insurance companies want their money. So it can be that they want to protect employees too, but you know, that's just my sense. And then the other reason that they say that they brought this forth was to protect the law-abiding businesses and to get rid of any unfair competition from companies that are cutting costs by misclassifying workers. I'm going to hand it back over to Shannon to talk about the exceptions under AB 5. These ones are quite confusing, and this is where there's going to be a lot of gray area going forward, and I think we'll see a lot of activity in the court systems, but this is what we need to try to comply with at this point.
That's correct. So AB 5 exceptions, and if you actually read the language of the statute, it reads like a maze. It is complicated. So, but to break it down, there are 7 groups of exceptions. We don't have time to go over all of them, but just so you know what they are, it's the occupation exceptions, the professional services exception, real estate licensee and repossession agency exception, business to business exception, construction subcontractor exception, referral agency, and also the motor club services. Today, we're going to focus on the occupation, professional services, and the business to business exceptions because those seem to come up more frequently. And it's important to keep in mind that with these exceptions, one of the good things about this legislation, it does say that these exceptions apply retroactively to any existing claims and actions to the maximum extent permitted by the law. So if a business is being sued already, it can take advantage of these exceptions now because they do apply retroactively. So that is good. Okay, so moving on to the occupation exceptions, and there's really no rhyme or reason. It's just kind of random different occupations that are listed that are accepted. And they are insurance agents, physician, surgeon, dentist, podiatrist, or veterinarian, a lawyer, architect, engineer, private investigator, accountant, securities broker, dealer, or investment advisor, a direct salesperson, and even commercial fishermen, subject to certain limitations. And what you notice on the slides is all of these professions, they need to be occupations, the individual needs to be licensed, have a proper license or registration. And now if the occupation meets this exception, if one of your workers, you then need to look at the Borrello test. So the analysis doesn't stop. But what it means is you don't have to comply with a more stringent ABC test. So that is the occupation exceptions. Moving on, the professional services exception. And again, it's really no rhyme or reason, but there are certain occupations or professions that fall under this exception. And under the code, professional services is defined as, we have marketing, HR administration, travel agent services, graphic design, a grant writer, a fine artist, a licensed enrolled agent, payment processing agent, a still photographer or photojournalist, a freelance writer, editor, or newspaper cartoonist, and licensed estheticians, electrologists, manicurists. That'll actually expire for manicurists in 2022, barber or cosmetologist, subject to certain requirements. So as you can see, that's a very varied list. And it's important to note for the photographer and the freelance writer exceptions, it only applies for individuals that do not submit more than 35 submissions per year. And then we're not done there with the professional service exception, because there are many factors that have to be met as well to fit within that exception. And these 6 factors include whether the individual is maintaining a business location that's separate from the hiring entity, and it can be a residence. It doesn't mean that the individual can't go to the business, the hiring entity's location and work, but they still have to have a separate location where they also perform work. Number 2 is if the work is performed more than 6 months after January 1st, the individual has a business license and any other license they need to practice their profession. So basically the legislature is giving people time in order to get the license they need to meet this requirement. Number 3, the individual has to have the ability to set their own rates for the services. 4, they also have to be able to set their own hours. Number 5, they have to be customarily engaged in the same type of work that they perform for the hiring entity with other customers. So you cannot be their only client. And then 6, they have to be customarily and regularly exercising discretion and independent judgment in the performance of the services. Moving on to the business-to-business exception. This one does not list out certain types of businesses, but has 12 criteria. Again, all of these criteria have to be met. The first one is that the business service provider is free from the control and direction of the contracting business. That's similar to that factor we discussed under Borello. The second one is the business service provider has to be providing services directly to the contracting business rather than to the contracting business's customers. So they have to be giving the services to the contracting business. The third is there needs to be a contract in writing. The fourth, if there's any license or business tax registration required, they have to have that. The fifth, they have to maintain, again, a business location that's separate from the business or work location of the contracting business. 6, they have to be customarily engaged in an independently established business of the same nature as that involved in the work. So they need to have other clients doing the same type of business, or at least holding themselves out to the public as available to perform those services. The next requirement is they have to be actually contracting with other businesses to provide the same or similar services. Talked about that, but they stated another way again. And then the business service provider needs to be advertising or holding themselves out to the public as available to provide those services. So they specifically require they have to be advertising. The next requirement is they have to be providing their own tools, vehicles, and equipment. So they have to be incurring the business expenses for their services. And then the business service provider has to be able to negotiate their own rates, set their own hours and where they work. And finally, it cannot be any work that's requiring a license from the contractor state license board. Important to note, this business-to-business exception does not apply to an individual worker. It only applies to a business entity. What is confusing here is though the legislation does say a sole proprietorship is considered a business entity. So there's a little gray area over whether an individual is an individual worker versus are they a sole proprietor that will be accepted and allowed to take benefit of this exception. Now we're going to turn it over to Wendi, who's going to talk about why classifying your workers properly is so critical.
Right. Those exceptions confuse me. There's a lot of gray area, but the reason why it's so important to take this seriously and to make sure that they do meet all those requirements is because the legal exposure for improper classification is really expensive to employers. So we are going to see an increase of EDD audits, and we've already been experiencing those. I've been working with some clients that are simply getting audited for producing 1099s, and it's just purely the number of them, and then having to go through with EDD with a response looking at the independent contractor agreements where they're getting very granular. And this has resulted in California state income tax and unemployment insurance violations and penalties. The big one where there's tons of exposure is the wage and hour violations. So with this, claims can go back to up to 4 years pursuant to the section 17200 code. So this can be huge because the wage and hour violations include 1 hour for missed meal periods, 1 hour for rest periods for every day the employee works. There's also overtime claim violations, and because the burden of proof is on the employer for timekeeping, there's going to be a lot of gray area there for how we're going to determine those hours. Plaintiff attorneys are looking for claims. They're looking for plaintiffs that want to pursue this, and they're out there. There's benefit eligibility violations under the American Affordable Care Act, which requires that workers are provided with benefits. Workers' compensation violations. If the insurance companies are looking and auditing this as well, when you're going for renewals, they're going to be looking at your 1099s now to see if you should be paying premiums for these workers. And if there's exposure and there's an injury, the employers are going to be liable for that, and there could be lawsuits associated with that. There's also the sick time violation for not providing the required California paid sick time. So all this can add up to substantial amounts that are going to be exposed by employers. So the recommendations that we have been making to our clients and to, Shannon and I are both on calls with clients and with even personal people. I had a friend call me yesterday about a caregiver. I had my sister call me who has a consulting firm on how to handle this. So our recommendations are that you analyze relationships with each of your workers that you have currently classified as independent contractors to ensure compliance. Seek professional or legal counsel to review those independent contractor agreements that you have in place. If there's not a misclassification, you probably need to actually have the new IC agreements created, your independent contractor agreements created that are compliant with AB5. It's just a good practice anyways to ensure that you're not having exposure. If there is a misclassification, work with somebody to create a strategic plan, a communication plan on how you will set forth in reclassifying this person as an employee, and execute conversion plan of your 1099 to W-2 employee, or eliminate the independent contractor position from the organization. With that being said, we're going to open this up to questions and answers. We will do our best to answer the questions, and if we don't know, we will research and get back to you. But feel free to ask any questions at this time.
So we do have a question currently. Can you hear me?
Yes.
Excellent. Let's see. Steve Garcia, if I use the service of an independent contractor who is out of the state of California, for instance, North Carolina, do these rules apply?
Okay, I'll take that question. So I would say the short answer is no, the rules don't apply because this is California law. So if there's an independent contractor outside California, then you don't need to be concerned about AB5, but they must truly be working outside California. And I think then you don't need to be concerned.
Are there other states that have similar, or do you see the other states following California in this? So something you need to look at the other states' laws, correct?
That is a good caveat. You do need to then look at the law of the other state. You may not need to worry about AB5. But some other states like Massachusetts has the ABC test. Then you would need to make sure, you should make sure that you're compliant with the employment laws in that state where that worker is located, to make sure they're still properly classified as an independent contractor.
Cool. All right, so there's a couple of other questions. Robert asked, in the entertainment industry, do you know how the studio production companies will handle payments to loan out companies or actors?
So that is a big question right now. And I know some organizations have taken the approach that loan out payments will not be affected by this. The collective bargaining agreement should apply. That is really not settled, and so I can't give you a firm answer on what is going to happen as a result of that. There is, under the exception for the professions, it does state that the movie, that as far as like photographers, it doesn't apply for motion pictures. So I mean, that's beneficial, but as far as what is going to happen ultimately with loan out companies, I'm not sure, and we'll have to stay tuned.
Right. Well, yeah, there's a lot of questions out there. The next question from Dean Rollis is, does retention of a quote unquote virtual assistant in California or outside California raise this issue, or an employment status issue?
Well, I think first you have to look at whether this virtual assistant are they working for a business? Are they working for a company, corporate entity? Or are we talking about a virtual assistant that is just an individual who does some, virtual, help? Because if it's a business, it may fall under the business to business exception. If it's an individual, then you still need to be concerned. So, and then the next question is, where are they located? If they're in California, you absolutely need to look at AB5. If they're outside California, then the question is whether whatever state that they're in, whether you're complying with those laws.
Right. So, we use Fiverr and Upwork, where we're going through a service to hire individuals. So you're saying that we just have to look at where they are and see what the laws are around that.
That's correct. I mean, if you're working with Upwork, because you're working with that entity, it most likely, you'd have to look at whether it falls under the business to business exception. And really, I think what AB5 is designed to do is to really target where you have people that maybe they've incorporated, but it's really just them. They're not working for a larger entity, and they're being treated as independent contractors, but really working as employees. And I think that's what AB5 is really targeted at cracking down on. So as far as Upwork, I'd be less concerned with respect to that. And I think that there still should be analysis, but I think that may fall under the business to business exception. And that's where I would start with looking at that.
Okay. So the next question is, let me go in order here. Is a person doing the work incorporated? Yeah, so I think that we answered that question. If they're incorporated as a business, but again, if they're doing the same thing that you're doing and you're the only client, you're going to have a problem with that. But I guess I'll let you answer that question. If the person's incorporated, they're a separate entity and they're working for your firm, does that become liability?
Yes, it does become a liability, because they have to still meet those 12 criteria, have to be satisfied under the business to business exception. So we're seeing a lot of it, I think a lot of people are trying to get incorporated to protect themselves and go that route, but that does not necessarily protect you, because they have to meet those 12 criteria. So take a look at what those 12 criteria are that we went over.
So Wendi, are we doing a lot of stress therapy for CEOs in California? Because my tension's rising even just talking about this. So.
Super high. That's why I've been trying to do proactive, give you guys the public service announcement and get some support and help.
Wow, it's amazing. So thanks for the question, Jim, because I have the same one. Is, do small companies have exposure? He says we only have 6 contractors in California. Well, no, let's see, we only have 1 ongoing contractor in California and 6 in other states. So is there a threshold, a number threshold?
No, there is no number threshold. This applies to all hiring entities, whether you're a small business up to, you know, a huge business. So yeah, there is, you will still, I would recommend you should still look at what that contractor in California is doing for you and whether, you know, they are classified properly or not. And if they fall under an exception, and even if they fall under an exception, again, the Borello test will still apply. So there should be an analysis of whether that person's properly classified.
Right. Lovely. Okay, so Sam, does it make a difference where the company is headquartered? Yeah, let's say they're headquartered in Texas, but the workers are from California. Does that change things at all?
No, that doesn't change things at all, because if the company headquartered elsewhere has workers in California, California law will apply to those workers.
Even if that worker's not working for you?
What do you mean they're not working?
So for instance, let's say that in some cases you're, you know, like in the sales tax world, if you take a distribution from Amazon and they have a facility in California, you might have California tax. But so let's say that the company that you're hiring has 10 employees in California and the rest of them are in Texas, but your employees are all your quote unquote independent contractors are all out of Texas. Are you okay, or does because they have any employees in California you're in trouble?
Well, I think if I understand your question correctly, you're saying that if the business that you're doing business with has its own employee workers in California, you have to be concerned.
Yeah.
No, you have to look at just the relationship. You don't need to look at the business you're working with, their relationship with their workers. The important thing is to look at whether it meets the business, you know, the business that you're actually doing work with.
Got it. Okay. So it's really that direct relationship.
Correct.
So this is a little more complicated, but maybe you have a couple of bullet points. Dean Rollis has asked, you know, you say we need an independent contractor written agreement, a new written independent contractor agreement. Is there a couple of magic terms that we need to have in there? Is there some zingers in there that we need to think about, or is it just the whole agreement?
Well, I mean, you don't necessarily have to change the entire thing, but the agreement should be reviewed again and should be tailored to fit under whatever exception you're trying to meet. So, you know, I like to include certain buzzwords like, you know, that the person's licensed, that they're setting their own hours, they're setting their own rates. You know, basically anything that shows that they're really an independent business and that they have the freedom to perform their work however they, you know, need to get the job done. But again, I would still recommend making sure that you do that analysis and figuring out, you know, if they meet one of those exceptions. If not, have you met the ABC test and looking at each one of those prongs? Because even if you write an independent contractor agreement, that sounds nice and all, it still needs to, the reality needs to be that they're going to meet that ABC test despite whatever you put down in writing.
Something that has been frequent in my analysis and review of independent contractor agreements, especially around grant writers and freelance writers, is that the employer wants to have the proprietary rights of what is being written, and there's language in there about made to hire, and that has completely nullified the independent contractor agreement when being audited by EDD. So they're just certain things that you should have legal review to make sure they're properly written.
Yeah, I thought about this for a while, and I'm not sure if this is an exception. So let's say I have 3 employees. I give each of them 5% of my company, and instead of making it a payroll expense, I make it an equity distribution or a you know, whatever you want to call it, K1 sort of thing. Is that a way to get around this issue at all?
That is definitely something that people are looking at doing, is making their, I guess, their workers part of the business itself. And owners or, you know, members of an LLC to get around this, and that potentially could work. There is no case law on that since this is very new, but that may be a workaround.
Yeah, the challenge is if the person's making 70,000 a year and your profit is 100,000 a year, you can't say, oh yeah, I'm giving them 70% of the distribution of the profit. I'm sure if it does come to a legal action, it would be that would be a very big question. Right.
Right.
That's tough. All right, let's see what else we have here. Under the professional services exceptions, is a business license sufficient, or does it have to be a professional certification? Peter runs an office of executive search consultants who are separate LLCs from mine. Can an executive search quote unquote recruiter be considered an HR administrator?
Okay, so for an HR administrator, the work still has to be predominantly intellectual and varied, can't be standardized. So potentially, if it's an HR, well, you're asking if a recruiter can be considered HR administration?
Right.
That's a good question.
I mean, that is a good question, but when I look at this and it says it has to be varied, if they're just focusing on recruiting efforts, I would be concerned about that.
Yeah.
Well,
unless they are providing those search services to other businesses.
yeah, Peter, you can unmute too, and if you want to clarify that.
Yeah, I would say that it is intellectual and it is varied, and we work under a retainer basis. So when our clients engage our consultants, you know, that's a dedicated project that has a start and an end, and my consultants might do a dozen of those a year. Again, they are intellectual and they are varied. But I guess the other question I have is, if you qualify under the professional services, do you also have to qualify under the B2B exceptions, or is it one or the other?
It's one or the other. Professional services is entirely business to business. So as long as you meet one of the exceptions, then you look to the Borello test to see whether they're properly classified. But if I understand you correctly, you have a recruiting business and you have consultants that do recruiting. Is that correct?
That is correct. And it could be or would be further complicated by the idea that I plan on having a succession plan in the next 5 years, where equity would be allocated to you know, my top performers, and then the other people would stay you know, in a position of an independent contractor. But regardless, each one of them has their own independent LLC, and they were paid by my LLC. Some of them do work for other people outside of our agency, but most of them are dedicated to working with me and us. We are a global firm, but I own shares in a global firm that gives me the rights to Southern California. So there's a lot of complex elements.
Your situation is on the answer, and I'm going to give you a quick answer, but I would think the first thing to look at, I'm not sure whether a recruiter is going to be considered HR admin. I would be a little hesitant to just rely on that. I'd probably look at the business to business exception to see if that can apply. That's probably where I would start the analysis. And the issue is, if you don't meet one of these exceptions, you then have to apply the ABC test, and your workers are doing the same thing that's the purpose of the business, which is the executive search recruiting. So
well, I think under the B2B exceptions, the toughest one is, you know, are they working for us or for clients? It's kind of both, because the client can technically be considered a client of the recruiter, but in some cases it's a client of theirs and ours. I mean, we do a lot of joint work, and it's, you know, every search has its unique profile and length and, you know, number of participants and all that. So this is a really complex field to you know, of minds to navigate. It's just incredible.
Yeah, yeah. You're right. They are doing work for your clients. So that probably likely would knock you out of that exception, and then you'd have to look at the ABC test, which again.
But in almost every case, it's the independent contractor that wins the client, and they just bring it in under the umbrella of our organization because they get support of a variety of ways administratively. I don't know. I think I'm going to have to just hire an attorney and try to get through the whole, you know, the entire analysis and reconfigure our contracts with each person accordingly.
Yeah, it sounds like, especially since some are working with other clients, it's going to be a different exception. Under a different exception, it could be B&B. So yeah, I definitely would recommend that you work with somebody to go over each individual person that you have working with you.
And so this is new to this year. So essentially we would have 12 months to kind of come into compliance, so to speak, or do you have to be under compliance from January 1st, 2020?
You have to be in compliance as of January, and actually possibly before then, because the Dynamics case came into effect in April 2018, and AB5 is just solidifying that, but giving people some exceptions. So I'd recommend that, yeah, you go on this now. Yeah.
Yeah, isn't that lovely?
Thank you.
The look back for 2 or 3 years, isn't that great? So we didn't know this was going to happen, but we, you know, have to pay for something we should have predicted was going to happen. I don't understand that at all.
Government and fairness are usually not in the same sentence.
Yeah. Yeah. And then Brendan asked a similar question. It says, how much exposure is alleviated by leveraging a staffing agency? And does that then put the burden on the agency itself? So I don't know if you have an opinion on that.
Well, there's a referral agency exception. We haven't gotten into that, but if the business is doing, you know, using contractors through a you know, referral agency, you may meet that exception and won't, you know, and be okay. So the concern is less when you're working with a big staffing agency. That staffing agency is then should be taking on a lot of the liability, although you could be considered a joint employer. So it is still important to look at that.
Okay. The next question, from Jim, we sometimes match public relation freelancers to short-term client assignments, you know, maybe 2 or 3 months. Is the client or the company required to classify the freelancer as an employee?
Trying to understand the question. Just for clarification, what do you mean by does the client or your company? So if they're working for you and you are putting them with a client, then it would be your responsibility to classify them properly.
So it's a freelancer.
Yeah, can I clarify, Forrest? Yeah, we do executive recruiting as well, and sometimes we'll do freelance assignments where a client of ours will say, hey, we're just looking for someone short term. So we're not technically a staffing agency, but we'll mark up the rate of the freelancer and take a portion of their fee and then have them work directly with the client, our client. So do we have to make that freelancer an employee of our firm, or the client has to make them an employee of their firm, or do neither one of us have to do that?
Well, they probably need to be an employee of somebody. The client's paying you to find that person, and then they could hire that person. But if you're paying that individual who's doing the work, you would definitely want to look at whether they're properly classified.
And
Yeah,
does,
if we go back to the reasons why legislature passed this, it's really to protect the employee. So if the employee is not getting their rights from you or from the client, I mean, it's not in the favor of an employee, and that California state's always looking for what's in favor of the employee.
do they also look at the consideration of the rates that these freelancers make? Because some of these freelancers are making $150 an hour. We're not exactly taking advantage of Uber drivers making $15 an hour. So they're making, you know, six-figure salaries, many of them, and wouldn't want to be classified as employees in many cases, in most cases, in public relations.
Unfortunately, there is no threshold. And the other thing that you need to be aware of, it doesn't matter if the individual, your worker, wants to be a independent contractor. That's the case a lot of times, beneficial to them, but it doesn't matter. It still has to comply with the law.
Okay.
Yeah, unfortunately, I'm in the same boat with some of my independent contractors. They want to maintain that, you know, it benefits them, but in order to comply with the law, I need to switch them over.
And does public relation qualify as marketing, sometimes under that category? I saw marketing was an exception for freelance.
That's remained to be seen, because literally this law just took effect, and there is no case law on this or challenge to that. So, I mean, I would recommend it to clients, they really look at what this statute says and just take it on face value and not try to get creative.
Or take a chance, right? I mean, you know, I think that's where a lot of people have to look at the cost of compliance versus the risk of liability. And the problem is if you're risk averse, there's no way around it. You know, it feels like it. You just have to comply. And for some businesses, a lawsuit with back pay for 4 years, 4 years, by one or multiple employees can put them out of business. And you know, then we have to call Dean Rawlis, right, or some of the bankruptcy attorneys here, because you know, these are massive liabilities when you talk about overtime and breaks and all that for 3 or 4 years. You know, right, Shannon? I mean,
that's right. And the other thing to keep in mind is that attorney fees are recoverable for the other side. So that's a huge reason. That's what's really motivating these claims too by plaintiffs' attorneys, because they can get their attorney fees.
Right. So I specialize in relocating companies out of California to other states that are more reasonable. Just give me a call. We'll handle that later. And I'm sure there's a couple of corporate attorneys on the line here that can create everybody's equity program that we're now going to implement across California. But we do have a question from Anna here. I don't know if you guys can see it in the chat. It's pretty lengthy, but for everybody else, we're talking about equity units and making a previous employer a K1. My understanding is that you can offer a guaranteed payment to the K1 employee for an agreed amount, say monthly, and then they can still have a 5% profit interest as well. You know, I guess the question is that a I'm sorry, a K1 owner, not an employee? Could that potentially be our exception?
Well, like we were talking about earlier, if you make the worker, you know, have an ownership interest and they're really an owner or a member of the LC or whatnot, then that could be a potential workaround, and that's what people are looking at. You know, it remains to be seen how it's exactly going to play out, but that is a potential way to try to avoid this issue.
Yeah, we have several corporate attorneys on the phone. I'm wondering, you know, sometimes we talk about putting together a phantom equity arrangement with our employees to make it sticky. So they're they are treated like equity, but they're not real equity. So there's another wrinkle in the equation that could work, but as soon as there's case law that says contrary, it could be a problem.
True. Agreed with that.
All right. Any other questions? We have 8 more minutes with Wendi and Shannon. Pam, did you get your question answered? You asked me a couple weeks ago.
I was just concerned about, the contractors, the independent contractors through Upwork and those kinds of organizations where we outsource some of the work.
But somebody laid off a whole bunch of people, right, Pam? It was
Yeah, so BuzzFeed fired a bunch and Vox fired a bunch of contractors.
and they were writers.
They were mostly writers, but they're independent contractors. They wipe the board clean. Until they figure it out, they can't have them working.
Mm-hmm.
Yeah, they tried to seek an injunction against AB5 from being applied to freelance writers, and it got denied. So it's still that freelance writers are still being affected, and that 35 cap on content submissions can be really difficult.
Wow.
Yeah, I'm working with a client right now in the entertainment industry that's also going through that. And these are people that make well into the 6 figures, and it still doesn't matter because they're writing over 35 submissions.
So that's the ticket, the 35.
Mm-hmm.
So Wendi, Shannon, we've had about 4 or 5 requests for your presentation deck. Is it possible if we provide you the contact list that you can shoot that out to the group?
Absolutely.
Okay, that answers that question for Robert and some of the others. And well, great. I want to thank you guys both for presenting this. I'm either going to do yoga or a scotch right now next. I'm not sure which, or maybe there's a balcony. There's a balcony behind me. I don't think I would jump, but I'm going to go look out there.
You're hilarious. Love it.
And but I appreciate the input. It certainly is a complicated issue. We'll look forward to updates as we go forward. And Wendi, look forward to seeing you in our meeting next week. And thanks everybody for joining us. And we'll look forward to seeing you guys at all the meetings.